If you're a personal injury lawyer in Georgia, a case you need to be aware of is Taylor versus the Devereux Foundation. That's the case where the Georgia Supreme Court upheld the constitutionality of Georgia's punitive damages cap as applied to the facts of that case. Taylor arose out of a sexual assault of a young girl at a behavioral health facility that the Devereux Foundation operated. The girl's representative filed suit against both the Devereux Foundation and its employee that assaulted her. After a jury trial, the jury returned a verdict of $10 million in compensatory damages and $50 million in punitive damages against the Devereux Foundation. The punitive damages claim against Devereux was based on a claim that they acted with an entire want of care. Now, Georgia has a punitive damages cap that caps punitive damages at $250,000 with some exceptions. Those three exceptions are product liability claims, claims where the defendant was under the influence of intoxicants, or claims involving a specific intent to cause harm. Because none of those three exceptions were present, the trial court capped the punitive damages award at $250,000, and the appeals followed. Now, on appeal to the Georgia Supreme Court, the plaintiff argued that Georgia's punitive damages cap violated the right to trial by jury under the Georgia Constitution. In analyzing this claim, the Georgia Supreme Court applied the Nesselhut framework. That's a case from more than 10 years ago where the Georgia Supreme Court held you look at the right to trial by jury that existed in 1798 when Georgia's Constitution was adopted and determine, did a right to trial by jury exist for that type of claim and those type of damages? And that's the analysis the court engaged in this case. In evaluating the case law from 1798, the court said you look at two things. One, you look at Georgia case laws of 1798 and English common law as of 1776. That's because in 1784, Georgia adopted English common law as the law of the state. Now, in evaluating the legal landscape that existed in 1798, the Georgia Supreme Court was unable to find a single case that had held there was a right to trial by jury for a claim of punitive damages where there was an entire want of care. What the court did find was that there were claims where there was a right to trial by jury for both premises liability claims and punitive damages claims involving intentional misconduct. The problem for the plaintiff and Taylor was there was no claim that the Devereux Foundation engaged in intentional misconduct. So the Georgia Supreme Court enforced the cap and held it did not violate Georgia's constitutional right to a trial by jury. Now, this case is important for three reasons. First, the Georgia Supreme Court reaffirmed the Nesselhut framework. In all future cases where a statutory damages cap or a claim that a statute or law violates the right to trial by jury, the court is going to engage in that analysis and look at the right to trial by jury that existed in 1798. The second reason that it's an important case is that it did uphold the constitutionality of the caps for claims involving an entire want of care, which is a common basis for punitive damages awards, and it's something that plaintiffs need to be aware of. But the third reason it's important is because the court did signal that there may be times where the cap is unconstitutional. And that's because there's an exception in the cap for specific intent to cause harm, but there's not an exception for intentional misconduct. Now, you could arguably have intentional misconduct without the specific intent to cause harm. And if you have that present in your case where there's intentional misconduct, you need to make sure you plead it in your complaint and you do discovery on it, and that you preserve the record by making the arguments at trial that the cap would violate the Georgia Constitution. Because in 1798, as the Georgia Supreme Court recognized in Taylor, there was a right to trial by jury for a punitive damages claim where intentional misconduct was at issue.